Now, on the record, the judge says that's not true. There were no individualized assessments of employees. They were all just fired collectively, right? This judge is mad. Because the states can't grift a portion of the employee's income, that's a harm to the states such that Trump can't fire them. Even the red states who don't want this crap, who don't feel burdened by anything, have to hire these people back, right? They're not even a party to the lawsuit. Big ruling out of Maryland from another corrupt federal judge. This one is the case of the state of Maryland versus the Department of Agriculture. This is a lawsuit, of course, they brought against Trump saying you can't fire everybody in the Department of Agriculture. Okay, so what happened, of course, as we've seen, is Doge came in, said, we don't really need all of you useless bureaucrats in here, so you're fired. Get out. Afuera immediately. And what has happened is the state now apparently is representing all of those fired individuals and is suing to get them back. But this was a federal judge ruling against Trump, writing the following, saying, when the federal government terminates large numbers of employees, including those still on probation because they were recently hired or promoted, it must follow the rules. Some of those rules are intended to help states manage the consequences of mass firings. Workers who unexpectedly lose their jobs, who often need immediate assistance, have to go to the states, and then the states are overwhelmed. And so if the states don't have advance notice, and if the states don't have the opportunity to plan and organize and to reprogram, then the states are harmed, okay? So Trump can't do anything at the federal government unless he checks in with all of the states. And Tish James in New York is like, that's okay, you can start firing people now. Then we're not going to be harmed because we're ready, because we got all of our Democrat layoffs firms situated. Now, in this case, the government, Trump, conducted massive layoffs, but it gave no advance notice. It claims it wasn't required to. Trump said, I can fire whoever I want, whenever I want, however I want. It says it dismissed each one of these thousands of probation employees for performance or other individualized reasons. Now, on the record, the judge says that's not true. There were no individualized assessments of employees. They were all just fired collectively, right? This judge is mad. Accordingly, in the language of the relevant rules and laws, these big government layoffs were actually RIFs, reductions in force. And because they were RIFs, they had to be preceded by notice to the states that would be impacted. And so because they did not have the notice, the states weren't ready for the impact of so many unemployed people, and they're still scrambling, and they remain impaired in their capacities to meet their legal obligations to their citizens. Now, because the federal government and their recent firing of thousands of employees was not executed in compliance with the rules intended to ensure that the states are ready to bear upon the load cast upon them when mass layoffs occur, and you're asking yourself, Rob, and you're sitting there, is this in the Constitution anywhere? Like where the executive branch can only execute the law when the states aren't going to be harmed? Like, is that anywhere in the Constitution at all? And because the plaintiff states are not in fact prepared, and because of the violations, the recent directives of various federal agencies must be stayed, okay? So if you're a probationary employee from the federal government, this president judge just hired you back. Now, in the accompanying TRO, the illegal RIFs are stayed for 14 days. Now, during which point, the court will likely consider a longer term injunction. And a TRO restores the status quo. So employees who are purportedly terminated under these RIFs are returned to the government's employment. They resume the status before the government acted, all right? So all the people who were fired are all brought back. It's crazy. And the judge just did it. Unelected judge from Maryland. So this is 19 states, including DC. They filed a lawsuit. They said, you can't fire these probationary employees. And they say, look, you have to, in federal civil service, which is not, it's federal bureaucrat employment, grifting jobs. Most employees are considered to be under probationary status in the first year or two of their employment, U.S. Code. A probationary employee may be terminated because of work performance or conduct during this period. For reasons on other conditions, they give us the rules. Now, if they're terminated, the agency shall terminate by notifying him in writing and separation and all these rules, Code of Federal Regulations. Again, it's not even a statute. It's the regulations that he's citing. Code of Federal Regulations. It's not in the Constitution. In addition, when conducting a RIF, you got to follow the regulations, which no one cares about. I mean, he does, obviously, but the Constitution doesn't. And the notice in the regulation must provide the employee or the employee's collective bargaining, blah, blah, blah. Maybe if it's some agency, okay, some agency head who's doing it, they say, well, we got to do a RIF. Okay, how are we going to do it? Blah, blah, blah. Go through these processes. But requiring the president to go through all this crap, that means the president is subordinate to OPM, and the president needs to consult with OPM, and the president needs to consult with the Department of Labor in order to do the jobs that the president is constitutionally entitled to do. It's like lunacy, right? This is tyranny by bureaucracy, and this judge is applying it to the executive branch. It's nuts. So the states in turn are required to carry out rapid response activities. Again, Code of Federal Regulations, and the states have to catch all of these fired bureaucrats bureaucrats. And Maryland is suffering now. Now, the government came in on February 11th and nuked all these bureaucrats, these so-called civil servants, who then they serve America so hard that they sue you and demand their jobs back because you're too stupid to realize what's good for you. And they're going to serve you whether you like it or not because they're civil servants. They just want to help everyone. This was followed by several more agencies firing these useless people. And all told, the states that the government has terminated, at least 24,000 probationary employees gone. The states were not provided any notice of such terminations. And I guess that means the judge says the president can't do it. So the states got harmed. They say, we have rapid response and all these people are coming back into our states. It's going to hurt our finances and health insurance and blah, blah, blah. They say Maryland created a new website, and that was very expensive of them to stand up a broken website probably. And the state also says unemployment benefits are going to be harmed because we have to care for these people who got canned. Maryland got 813 claims. Here, California got 1,600 claims. Great. Illinois, 400. Great. You guys can take care of them. Okay. We can't afford it anymore at the federal level, so they can afford it at the states. Beyond the increased burdens, just go hire them if you want all these bureaucrats. They must be very talented because they just came out of the federal government. They can go work for you, Gavin. Now, third, some states also lost the benefit of other services. New Jersey, Rhode Island, and blah, blah, blah. In New Jersey, 3 PHAP associates, all of whom were working on infectious diseases, were terminated. Okay. Were they in New Jersey? Great. They can go find their infectious diseases in New Jersey then. CDC later reinstated the associates, but one of them didn't come back. His caseload was already transferred, and someone else is going to spread syphilis in New Jersey. I don't know if Fannie Willis is there visiting again or what, but fourth, the states allege that the government's actions will continue to cause irreparable harm to the tax base. Okay. Just think about how freaking annoying and pathetic this is. Like, you get fired from your job or you fire somebody from their job. They sue you and a judge says hire them back and you have to work together now. You're going to continue to work together. Right. Now, moreover, Dr. Clower estimates if fired workers are given the opportunity to find alternative employment, the tax losses would be significantly lower. So because the states can't grift a portion of the employee's income, that's a harm to the states such that Trump can't fire them. You hear how nuts this is? And the states say that this is textbook informational injury as well, and we're being harmed. And so this judge is going to, of course, grant this and say they're all hired back. It's already done that. So saying, well, we have the right to hear this case. There is standing from these states to come in here and complain against people, saying, yep, it is going to increase the administrative costs and unemployment and decrease tax revenue. The government fires people. The state can't skimp a portion of that off the top for their state revenue. That is a basis for not firing anybody because they won't get taxes. You hear how bizarre this is? These are Democrat politicians who are making these arguments. And this is a Democrat judge who's signing off on it. Now, as an initial matter, this court views these injuries differently than the states do. This is an injury. It's a RIF. Informational injury is valid. The states have asserted harm, and so they're here. Now, the court believes that they should be here. There is substantial risk that damages will occur. Now, the only thing that's not readily apparent is the loss of tax revenue. The judge is like, well, it's like it might happen. So on one hand, it says you can't establish standing by posting a long chain of events. But on the other hand, it might happen. Here, reasonable minds could differ as to whether this is valid. But the state comes closer to the mark that they will suffer income tax. And so we don't know if it's directly causally connected, but there are weaknesses in the theory, and the judge is going to say they have standing, obviously. So as we continue, causation. Does what Trump did actually cause the harm to the states? Judge is going to say, yep, clearly it does. And can we redress this? Yes, they didn't have notice. And so he's going to hang it on notice, essentially. And it is a final action, so we can address it here. And so this judge is going to grant the whole thing, right? So all these people got to come back saying they're going to win on the merits. Having determined the state can bring this claim and whether the states are going to file this, they will win. We say that these terminations were unlawful. Agencies can terminate people, but you got to follow the regulations. The regulations are more important than your constitutional power. And you can't just fire 24,000 people. It's simply not conceivable that the government, right, this judge, it's not conceivable because these bureaucrats have never done anything in their lives, that the government could have conducted individualized assessments of the relevant employees in the relevant time frame. No way you guys couldn't have checked that. 24,000 people, you can't go through and check those. A few hundred people, you just look at the files. Did they answer the email? Did they answer the email? 5 things that they did this week? They didn't? Okay. Did this guy? No. 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 Okay, you're fired. You're gone. All of you. Individualized. I can do it in 15 seconds, 15 minutes with a spreadsheet. Somebody can fill the data. I just sort the column. Okay, select all of these people, copy, paste, fired. Fire all of them. The states also provided affidavits from individuals saying we didn't get fired based on individual assessments. Like they want to have a sit down and a conversation and they want to go, get a reprimand and like 3 warnings employees and then go to a retraining seminar and do better and blah, blah, blah. No, you're fired. So the court says the terminations were not based on qualification. So this judge, again, is substituting his judgment for the executive branch, saying, I don't like how you did this. The execution is undermining the regulations, and so your constitutional powers can be damned. That these terminations were RIFs is because of the number. The Secretary of Labor in Maryland said that they were laid off due to a reduction in force, and the judge says it plainly looks like a RIF. The states have not carried their burden, though, of saying, with respect to three agencies, the DOD, the National Archives, and the OPM. So those can do terminations. While the court does not rely solely on those affidavits, the conclusion is without prejudice to the presentation of additional evidence. Now, the government did not follow the notice procedures, which are not in the Constitution anywhere. You can only do this if you give everyone notice. No, it does not attempt to argue that it did. Indeed, the government's substantive arguments are aimed only at its view that it did not conduct the RIFs, because the states have shown the government's actions were highly likely and not in accordance with the law. The judge says they're going to win, and the states will suffer economic damages, and it's going to be irreparable. So the state's diversion of resources will require them to come out of pocket, and we think 60 days is appropriate for notice. The public has an interest in seeing the government follow the law, and Trump's not following the law, and so he has to here. The government argues that a TRO would impose significant costs, but the court doesn't discount this. Trump says, we're going to hire all these people, but this is the only relief that is going to address this and to redress this. And so, before turning to what this judge is going to specifically order, he says the government fired these workers, and saying that if you make us hire them back, this would be an injunction, but the government's mistaken, okay, right? It's just a matter of phrasing. It's just artful pleading, saying, I'm not forcing you to hire them. I'm just demanding that you undo what you did, right? So practically it's the forced rehiring of people who were fired, but he says, no, I'm just saying that you didn't fire them. But we did. They're already gone. We already boxed up all their crap. No, just undo it so they were not ever fired. Well, that's an injunction to bring them back in. You're forcing us to, you're mandating the executive branch do something. No. I'm just telling you to undo what you did and preserve the status quo, right? Okay, judge. The judge says, well, what's the scope of this? Should this apply to everybody in the whole country? Obviously. The judge says here, in this circumstance, a nationwide injunction is warranted. So every employee from every single state, even the red states who don't want this crap, who don't feel burdened by anything, have to hire these people back, right? They're not even a party to the lawsuit. And so the court may do whatever it needs to remedy the unlawful agency actions. And the original remedy for this is a vacatur. So now the order is going to be vacated and the stay is in effect. So only an order staying the unlawful RIF is valid. Now, as a practical matter, a stay of the government's terminations of probationary employees means the government must reinstate all affected employees who work for the government. Then, if the government wishes to continue its RIF, the government must start from square one, acting in compliance with federal law, and give everyone notice. Only by following the procedures set forth in the federal law can the court ensure the states are ready for these firings. The court is not blind to the reality that the relief being ordered today will have far-reaching impacts to everybody and the considerable resources to undo all the firings. But as explained, we have to. When, as is likely the case here, the government has engaged in illegalities, we have to bring these back. So the final issue is about who is restrained, and the Defense Department, the OPM, and the archives will be excluded, but everybody else has to be hired back. Now, Trump asked for an injunction bond under Rule 65C. If they say a court may issue a TRO only if the movement posts a security bond, but district courts, here we go, have discretion to set the security a nominal amount, which means like $1, right? And so here the court concludes that a nominal bond is appropriate. So it's going to cost the U.S. government like, I don't know, $1 billion to hire 26,000 people back, whatever the number is. The judge is going to say, well, you only have to post, since you're suing, $100. Nuts, right? So I figured that was going to be the little escape hatch. So if it is mandatory, then they'll just make it very low. So post $100, and all of these states can force Trump and the American people who elected Trump and this new administration to hire back 26,000 people, and maybe then some. Although the risk of harm to the government is not remote, the potential cost of an improvidently granted TRO based on the federal government is too complex to calculate in this expedited proceeding. So I can't really calculate how much damage it would cost, so we'll just make it $100. And if it's too much, they can't file these claims. And so the government requests that an order for a stay be granted, but here there's not a strong likelihood of success shown by the government. And so this lunatic judge, James K. Bredar, terrible judge, wrote wrote this conclusion here: a TRO will issue. So Trump ordered to hire back all of these people. That came out from Judge K. Bredar out of Maryland.